Welcome to Counsel Culture, the Business of Law podcast brought to you by Byfield.
Hello, everybody, and welcome to Counsel Culture, the Business of Law podcast from Byfield. You'll have spotted by now that I'm not Meg today. Meg is having a very, very well-deserved week off. I'm Ben Gardler-Stones, and I am stepping in slightly with trepidation into the host chair. Big shoes to fill with Meg. So hello everybody, and I'd like to welcome our special guest, who is none other than my co-managing director here at Byfield, Michael Evans. Hi, Michael.
Hey Ben, how you doing? So it's going to be centrist dadcast today.
It's going to be, we are going to be channeling our inner Alistair Campbell and Rory Stewart, but we won't be treading onto their political toes, much as you and I do like a chat about politics. But do you want to be Alistair Campbell or do you want to be Rory?
Oh, that's a horrible choice to make. You choose.
Okay, I'll be Alistair. But you are actually away this week as well, aren't you? You're working away in Egypt, and I'm very jealously looking at your lovely vista behind you there. So yeah.
Yep. Nice to get away for half term for a bit, but also good fun to be doing the podcast. So yeah, what stories have we got today?
Yeah, actually, there's a lot to get through, isn't there? So I think it would probably make sense to start with some big picture analysis of law firm mergers. Clearly, A&O Shearman is well underway. Lots of stories coming about that around lockstep and things like that, which we'll get to a little bit later. But I think you wanted to kick off to talk about mergers, and particularly a law.com piece from this week, which kind of insinuated that perhaps some managing partners were slightly getting cold feet.
Yeah, well, it talks, when it comes to law firm mergers, our firm leaders getting FOMO is the title of the piece. It was at first in AmLaw, and now it's on Law.com International. And just a sort of a sense that there's a lot going on behind the scenes in terms of firms talking to one another, exploring possibilities, and there being a bit of a fear of missing out. Because I think, as somebody says in the piece, nobody's really making new law firms at scale. So options are a little bit more limited than they might have been 10 years ago or 15 years ago. So there's a finite amount of good deals to be done. And if they are transformational, and the trend is towards doing some of these transformational deals, you don't want to be left out or left on the shelf, which I think, whether it translates into a huge amount of activity or not, I don't know. But certainly get the sense of there being, quite a few conversations going on. There do seem to be quite a few rumours going around the market at the moment. There have been for a little while since A&O Shearman, but certainly the volume seems to have gone up a notch recently. So I wouldn't be surprised if we see some announcements over the coming months. The sector moves slowly. Nobody does transformational M&A deals overnight. And the legal sector in particular is cautious, and there are a lot of obstacles to overcome if you're doing a deal, if you're looking to do a deal, because it's not like two private companies doing it. You do need the partners to be on board, and there is that really difficult decision to make as to how to manage it if it starts to get around that you're having talks. I thought A&O Shearman, for example, did a good job of treating it and announcing it like a big M&A deal on a Sunday with an FT exclusive at the time, and kind of, I hesitate to use the word bounced partners into it, but it certainly created a framework where it would have looked awful. It would have been terrible if the partners hadn't fallen in line. So it's a big risk, but you and I have both seen many, many occasions over the years when law firm mergers have fallen apart because they've sort of dribbled out into the public domain before they're quite ready. And that's dangerous, because sometimes they dribble out because somebody who in the partnership is not keen on it puts it out there. Sometimes it just sort of limps out in a way which then, if the communications internally haven't been done sufficiently to prepare partners, they can take against it, and you lose control of the messaging around it. But equally, you can't you can't have extensive, detailed conversations in large partnerships without very, very significant risks of leaks, which then increase over time dramatically. So, I think that there is a big bet for management to take. If they're going to do it, there's an element of being all in on it and communicating it in that way, and living with the fact that if it doesn't happen, there'll be serious, repercussions for their status. And that's just the way it is. But I think that choice between to get it out there proactively on your own terms, even if it's not, everything isn't ready, versus trying to get everything ready but living with a massive leak risk, which may harm the prospects for deal, is a really interesting one. But anyway, that's those are my thoughts. What do you think, Ben?
So I'm really disappointed that we haven't seen more mergers come to market, or at least advanced stages, because I still remain really impressed at how quickly A&O and Shin managed to mobilise, and it did come from the ashes of the Hogan Lovells discussions very, very quickly. And if two firms of that calibre and structure and size can get together quickly in an organised way, I don't see why others can't as well. And I, like you, have heard all sorts of rumours, particularly of US firms being quite acquisitive with our, UK headquartered firms here. So I say, come on, let's get on with it. Let's see some more. I think the market is really, really wanting, some other big ticket mergers to happen. And as you say, I'm sure discussions are happening all over the place, but you're absolutely right. The longer they are, sort of taking place under cover of darkness, the more likely leaks will come, and you lose control of the message. So I would hope to see something pretty soon. Should we move on to our next story, which is around trainee salaries? We don't talk about trainees very often because the whole narrative around numbers and salaries and career progressions has been, for obvious reasons, around NQs, and particularly the salary wars which have taken place, particularly amongst the US firms, which have played out here in London. But I've been sensing a sort of shift in the mood music towards trainees and trainee rates, and a number of firms have come out and put trainee rates up in recent weeks. And yes, I know it was a special student law supplement today in the Times, but I think it's pretty telling that Jonathan Ames's lead story was around trainee salaries. And I think the focus of attention is going to be on trainees and the trainee experience, particularly at US firms, and remuneration is a big part of that. And I think that's going to be a big theme as we move into the rest of the year and early next. What do you think, Michael?
I mean, I think I defer to your instincts on that one, Ben. I think it's a natural progression from a focus on NQs, but also I think the training experience, in a way, there used to be more written about it, I think, than there has been of recent years, where there's been almost an obsession with NQs. And I think, but also the trainee experience is not just about salary, is it? It's about quality of training, the flow through to retention rates, and I think you've seen more and more of the US firms develop their own training schemes and taking on trainees. I think most of the larger ones do now. I think Paul Weiss are implementing one next year. I think 2025. So with their first intake. So I think you're right. I think it's normal. But I think it would be good if it was a bit more of a rounded discussion about the experience of being a trainee, rather than just to focus on the numbers.
Yeah, and I think that is absolutely right. And I'm also a little bit minded because I was speaking to the partner who is in charge of the trainee recruitment and the trainee experience at one of our big US clients last week. And he made a really interesting point. He was saying, if you're a Magic Circle firm, you might be taking on 40, 80 trainees at once. And how on earth do you have enough time to invest in them on an individual basis? They take on, some US firms, which are sizable, will take on maybe 5, 10, or maximum 15 trainees a year. And the amount of partner time that's available to spend with those trainees is just by weight of numbers, far more than in the Magic Circle and big UK firms. And I think that's quite telling. So, people often think, well, I'll just go to the US firm because I'll get paid more, but the experience might not be quite so good as it would be in a UK headquartered firm or a traditional Magic Circle firm. That might not be the case. You might get a better experience as a trainee because you get more senior partner time. And I think that's interesting too. If we move on a little bit, still keeping the broad salary theme, but moving on to partners, I've seen a number of pieces, particularly in law.com, looking at particularly US firms, the split between salary partners and obviously equity partners. A couple of meetings I've had with senior journalists, the lawyer and law.com in recent weeks. It's been quite a big topic of conversation. I think that US firms are going to start needing to be a bit more open about the split between equity and non-equity partners. To my mind, Kirkland have always been very open about it, or at least everybody knows kind of what goes on there, but other firms less so. And I think that when we hit reporting season, January, February time next year, and you've got the lawyers US 50 and other similar things, I think firms are going to have to be, or there's going to be a pressure on firms to be a lot more open about numbers of salary partners that they have or any tiers that they might have. I read with interest Tabiba's story on, I know Shim, and I think it was early this week or last week, where she really got under the skin of the tiers that were coming. And I thought that was super interesting. And I think that shows that my instincts might be right as we move into next year. What do you think, Michael?
Yeah, I think that you're probably right there. I think it's an interesting trend. Oddly, it's people talk about the Americanization of the UK legal market at the top end in terms of the sort of lockstep having gone, but equally, funnily enough, having large ranks of salary partners has been a hallmark of the bigger UK firms for a long time. So there's almost like a little bit, I wouldn't say it's an influence. I think it's more just it's evolved in such a way that it makes sense. It's very hard. I think Cleary Gottlieb was sort of clinging on to a all equity approach, and they've now shifted away from it, which is what sparks quite a lot of this coverage. And I think law firms are bigger, more sophisticated businesses, having bigger, more sophisticated partnerships and having a more evolved, slightly more complex, like pyramid structure kind of makes sense. You've also got to sort of, guarding the equity quite tightly isn't unexpected, and Kirkland's growth when they made changes to their business and really introduced this sort of big sort of massed rank of very, very talented kind of income partners sort of slugging it out to see, who would make equity. But then the firm was doing so well that those income partners were making as much as equity partners a lot of other places anyway. Obviously firms took notice of that. And I think it speaks as much to the evolving role of the equity partner as much as anything else, I think. And that's one thing that the coverage is overlooked a little bit. But, there's so much now in terms of, you're each equity partner in a big law firm is effectively overseeing a not unsubstantial business. Within a business, and they've got to oversee big teams. They're going to be managing client relationships. They're going to be bringing in business. They're going to have to be dealing with all sorts of things. And so I think as much as anything else, it tells us about the fact that equity partners, the role is considerable beyond what it was 10 or 15 years ago, and you can't just become one when you've got enough business coming in or whatever. It's not just about the financial metrics. There's a whole sort of package here, and I do think that it does make it harder to you can't become an equity partner and do all of that aged 30 very easily. And I'm not saying it was common 10 or 15 years ago, but it didn't have necessarily the same range of responsibilities for kind of running a P&L of some substantial size now and sophistication that you see at the biggest firms.
Yeah, the thing that interests me, actually, it's a slightly cynical point, been said of Kirkland before, is of salaried partners, how long have they been there, and did they join as senior associates from other firms with the dangle of the moniker partner? And the cynical point of view is, are some of these salaried partners really glorified senior associates with a shiny badge? That's always been the accusation leveled against Kirkland. I don't necessarily agree with it. To be honest, I don't know. I don't know Kirkland. I've never worked there, but if I was a US firm and I was thinking about this, I would actually have a look at your salary partners. Are they homegrown? Are they lateral hires at senior associate level? And if the latter, how are you going to describe that process? And I think that will be quite interesting. Right, we're going to change tack here, and we're going to have a look at some big ticket litigation. And really focusing on BHP, which is finally beginning its defence following the 36 billion claim for the Samarco dam disaster in Brazil. Now, I can't believe this has been rumbling for over a decade, hasn't it? So Slaughter and May, as I think as everyone knows, have been involved. And when I got there in 2014, this was a big thing at the top of everyone's list. And to take a decade to get to this point, to me, is quite remarkable. Now, I'm not quite as in tune with big ticket litigation as you are, as you know, but that headline in and of itself kind of took me back. I'm like, wow, we're a decade on and we're only here. What do you think, Michael?
Yeah, well, I don't know what to say apart from the wheels of justice turn very, very slowly. But the point is that it's interesting that this is happening here. There was a very eminent senior partner of a law firm, of a Brazilian law firm, who was speaking a little bit about this at the IBA in Mexico City a few weeks ago, and was saying that there's some in the Brazilian legal community who are sort of outraged that this is actually happening in English courts. But he was saying that they shouldn't see it. They should see it as it's a bit of a failure of the justice system in Brazil, that it's having to take place somewhere else, because wherever it comes out, you cannot argue that there isn't a case for redress. The scale of that redress, ultimately who precisely is, if it's a shared thing between Vale and BHP or not, is up for debate. But the case for redress is not, and the fact that it's having to be heard in a court in London does not say amazing things about justice in Brazil. That was what this very senior eminent partner from a Brazilian firm was saying, which I think is interesting. The sheer scale of the case, a 12-week trial with I think it's 600,000 Brazilian citizens, 46 different municipalities, and 2,000 businesses. So it's a vast scale. Obviously, it's an environmental disaster, which obviously touches on lots and lots of different things in today's age of climate change related litigation, but also the social responsibility, environmental responsibility and obligations that large corporations have towards the world and its people. So it is going to be fascinating to see where it comes out and the level of liability. I don't think the money itself is going to be quite decided. It's more about liability at this stage. Obviously, there have been attempts to settle it in Brazil, but the UK case is vital, and the fact that it's playing out here in London says, I think, a lot about the continued role of London as a global centre for dispute resolution when it is really complicated claims, and it absolutely needs to be worked through in a commercial centre with the depth of legal expertise, both in terms of firms but also barristers, to be able to literally do it justice.
Yeah,
I think that's the key thing. It's good for London.
I agree. I'm moving away from the sort of pure litigation angle. I'm interested in, from a reputation management perspective, BHP Billiton's, because this has been rumbling for a decade, obviously, with no sign of real closure anytime soon. And I kind of cast my mind back to the Deepwater Horizon spill. I think it was in 2010, and I'll never forget it. Barack Obama saying when he was president, "I just want to know who's asked to kick." And you kind of think, wow, if you're in charge of a company's reputation and the president of the US is saying that, then litigation probably is on your high on your to-do list, but not the only thing there. And I'm interested to see how BHP are kind of faring, but that's slightly off topic. And and I do agree that the complexity of these huge pieces of litigation are vast, and some real good reassurance that London remains a trusted centre for high profile disputes. So our final story is something I think that you wanted to talk about, which is slightly buried in the lawyer today, but very important. That the two biggest scandals really domestically that the legal industry has faced, for the post office and the Axiom Ince scandals, are finally. The SRA have hinted, and I use the lawyer's words deliberately, at some timing and a plan for how they're going to tackle each one.
Yeah, look, I mean, I think I don't think we need to spend too long on this. It's more just, I saw a piece today, the lawyer published a piece suggesting that it might be that prosecutions could be heard around the middle of 2025, and that budget's been approved. So, I guess all we're really looking at is that two of the biggest kind of overhang cases that are on the SRA's agenda, the post office scandal and Axiom Ince blow up. They are going to be tackling them. We know that it's taking up a vast and disproportionate, well, not disproportionate, probably proportionate, but it's taking up a lot of SRA resource and probably is impacting on their ability to move on to other things. So they do need to get these things done, and if we're looking at 2025, we should start to see things being scheduled. We should start to see things being launched. In terms of the SRA starting to contact firms, starting to get the process moving towards referrals soon, I would have thought, if they're looking at 2025 to actually mid-2025 for the cases to be heard. Obviously, there's still a lot of stuff outstanding in terms of the Legal Services Board is supposed to be investigating the SRA itself over its handling of Axiom Ince. So there are kind of the regulator that is trying to bring these claims is itself being investigated by its own regulator, which obviously has a bearing on timelines and credibility, and certain things need to move in sync, and there needs to be some choreography around all of that, which is difficult at the best of times. But when you've got regulators and regulators of regulators and regulated firms, obviously putting all of that together is not easy. But I think, it does look like we're going to start to see some things happening. So the firms that were involved and the individuals that were involved, I would imagine, are feeling a little anxious. Well, they've been feeling anxious for some time, but we'll start to get documentation, paperwork, and process-related things will be moving, I think, in terms of the SRA preparing the way for the formal referrals and then the hearings themselves.
Yeah,
so that's it.
You and I do a lot of work involving the SRA on a variety of different types of investigation and matters. And we both have done in previous careers as well. The sense I always get, and I've got admiration for this, they don't ever appear rushed. And I don't mean that in a slightly critical way. Even with Beckwith, where they got a lot of criticism over, they do their process. They don't respond they don't seem to be swayed by pressure of timing or anything else. And I've got a respect for them for that. Everybody knows they are a little bit short-staffed, and they haven't got as many people as industry observers might think. But they don't tend to rush things. They don't really respond to pressure in a negative way. I've got a grudging respect for how they go about things, the SRA. So I think we're finished with a little bit of a thumbs up for the SRA and a bit of professional respect there. So that brings us to a close.
That's an unexpected closing point.
Yeah,
somebody giving the SRA some love. Okay,
absolutely.
Right.
We love you.
I'm not sure if I agree with you, but let's do it anyway.
Absolutely. Right. So I think that brings us maybe to a close. We've clocked in at just about 25 minutes, which seems probably the limits of people's patience with us. So thank you very much, Michael. Meg, I'm sure you're listening in Brighton. I hope that you feel that we've done all right. And as you normally end with, we are available on iTunes. What are the other ones, Michael?
Spotify, all the usual places that you get your podcasts from. And we'll be back next week with Meg resuming her usual duties.
Excellent. Goodbye, everyone, and thanks for listening.
You've been listening to Council Culture, the Business of Law podcast brought to you by Byfield. Thanks for listening. Don't forget to subscribe and join us again next week, where we'll be discussing some more of the biggest stories in the legal sector.